and other members of the subcommittee. Thank you for this opportunity to testify. I'm a professor of law at Santa Clara University School of Law. I'm also a book author and a photographer, and my personal experience informs my scholarship and understanding of the importance of copyright to authors and artists across the country. In my testimony, I will discuss whether using copyrighted works to train AI models is a fair use, giving particular attention to the two recent decisions by Judges Alsup and Chabria in cases filed by book authors against Anthropic and Meta. This novel question of law, which has important implications for U.S. national interest, has sparked sharp disagreements among parties, stakeholders, and now federal judges. As Judge Bibas noted in an earlier non-generative AI case, this question of law is difficult. In my opening remarks, I would like to stress 3 points. First, I believe Judges Alsup and Chabria correctly concluded that the use of copies of works to train an AI model serves a highly transformative purpose in developing a new technology under Factor 1 of fair use. During training, an AI model is exposed to vast training materials, typically many millions of works. Through a process called deep learning, the model identifies the statistical relationships among words and within subparts of words, thereby enabling the model to conduct numerous functions, including research, translation, delivery of medical advice, generation of content, and so forth. As Judge Chabria concluded in his opinion, quote unquote, the purpose of Meta's copying was to train its large language models, which are innovative tools that can be used to generate diverse texts and perform a wide range of functions. And as Judge Alsup recognized, the technology at issue was among the most transformative many of us will see in our lifetimes. Now, the history of AI development strongly supports this conclusion. It is important to understand why AI researchers at universities began training AI models on large data sets. This practice originated not at AI companies, not at big tech, but at universities where AI researchers discovered a key insight. Scaling or using larger and more diverse data sets actually worked in developing and improving AI models, an achievement that escaped researchers for many years. This seminal breakthrough, which took decades to figure out, has propelled the advances of AI that we are witnessing today. Second, while I agree with the ultimate findings of fair use in both cases, it's important to remember that fair use is fact-specific and decided on a case-by-case basis. In some cases, a transformative purpose in AI training might be outweighed by the other factors. For example, an AI model that routinely produces outputs that are infringing, such as regurgitations, might not be a fair use even in the training of the model due to insufficient guardrails on the model. Critically, in the cases against Anthropic and Meta, the judges concluded the plaintiffs did not show the models had produced any infringing outputs of the plaintiff's works. And that can be appealed, but that is the findings